Hi, welcome to Module 5 or the Introduction to Social Legislation. This video lecture will be fairly brief because what we will be covering in this module we have already discussed in the first part of our uh, course. Right? Module 5 signals our departure from agrarian reform laws. As we have discussed, agrarian reform laws, they are considered as social legislation. Now, Module 5 signals that we will now move on to the other pieces of legislation which are considered to be social legislation. Right? And so in this fairly brief video, we shall discuss the basis or legal basis, more specifically the constitutional basis for social legislation. And secondly, we will discuss the nature of social legislation. And here in the discussion on the nature of social legislation, we shall be refreshed with our discussion on the meaning of social justice. And lastly, we will point out some categories, some groups of laws, kinds of social legislation, in order to put context as to where we are leading with regard to our course. Right. So let's proceed to the constitutional basis. All right. Foremost of the constitutional basis for social legislation is Section 10, Article 2, 19 of the 1987 Constitution, wherein, although this is in Article 2, and although this is considered to be just a statement of principle and therefore non self executory as of yet, right? Because there's a precedent, no? In where the court declared a portion or a provision or two provisions of Article 2. Although they belong to Article 2, they are, according to the court, self-executory because they vest rights. All right, they recognize rights. Now, I don't know yet with this provision. Perhaps there will be uh, development in our jurisprudence. But as of now, okay, pursuant to jurisprudence, except for those two, Section 15 and Section 16, declared to be self-executory, no? All the rest of Article 2 will still have to be considered as non-self-executory. Notwithstanding, that this Section 10, Article 2, may be considered as non-self-executory. This can be considered as a legal basis for social legislation, all right? Because here, the lawmaking body of the state is directed to promote social justice in all phases of national development. Effectively saying to the Congress, no, that in your attempts to make laws, to make regulations in all phases of national development, promote social justice. And how is social justice to be promoted by Congress? As we shall see later on, this is done by social legislation. All right, and also Section 1, Article 13 of the 1987 Constitution. Here, according to the court, to the Constitution, the Congress shall give highest priority to the enactment of measures that would, among others, reduce social, economic, and political inequalities. Right? And if we try to recall our discussion in the first part of our course, social legislation has this equalizing effect, or social legislation is uh, put there in the system in our legislative framework in order to address the inequalities that exist, all right, in our society, be it social, be it economic, and be it political in nature, all right. And because here Congress again is given the mandate not just to promote social justice, but to act, right, to enact measures, to do positive acts in order to reduce social, economic, or even political inequalities. And by virtue of Section 1, Article 13, we can then say that the existence of social legislation in our uh, in our legal framework, even though we are not a socialist country, no, we are primarily capitalist. All right, but because of these mga provisions under our constitution, we can justify the the existence of social legislation in our legal framework. No, uh, Section 2, Article 13 of the 1987 Constitution emphasizes, it's just a follow up on the first two provisions, no, cited. It here the Constitution clarifies that the promotion of social justice will have to include the commitment to create the economic opportunities based on freedom of initiative and self reliance. No, this separates us from a communist regime, for example, or from a strictly socialist regime. All right. Here we still maintain the system is still capitalist in nature, but because as I said, because of these provisions, because of these constitutional provisions, we can justify the existence of social legislation. We can just justify Congress enacting measures which treat people differently according to their needs, no? Such that the law gives more to those who need protection, more protection, than those who do not need protection or advantages at all. All right. And so here, even though social legislation sanctions, or in fact the very core of social legislation, there is difference in treatment. There is a difference in treatment depending on need. All right, this kind of law or this kind of legislation is perfectly acceptable within our framework. All right. Now, since, again, as I said, in this video lecture, we shall discuss the nature of social justice, I mean, social legislation, we shall also refresh our memories of the meaning of social justice. All right, because we've discussed already, no, what social justice means, and we have cited, and this case is oft cited when the discussion or the topic of the discussion is the meaning of social justice. I'm referring to the case of Kalalang versus Williams, and we have already discussed, right, the components of the definition. Again, I do not require you to memorize, but it's good to memorize. It's just good to. This is one of the oft cited uh, uh, lines, or yeah, or portions in jurisprudence, right? But As we have discussed already, social justice. Uh, this definition of social justice has two components, right? What social justice is not, and what social justice is, right? So it's not despotism, atomism. It's not communism, right? It's not oppression to those who are not treated favorably. It's not favoritism for those who are treated favorably. uh, but it's the principle of humanization of laws. It's the principle wherein the social and economic forces are equalized. All right, are equalized by the state, by no less than the state. All right, so that the concept of justice, no, because there's this very broad concept of justice, right? At least the concept of justice in its secular form, or secular perspective, would be approximated. No, very, again, I always say that this is a very intellectually humble definition of social justice, because it recognizes that justice may vary. It may vary from the perspective, all right, of one person to another, may vary from one culture to another, one nation to another. But at least recognizing the malleability of the definition of justice now, this definition aims not to provide pure justice, whatever that is, but to at least approximate. No, there is an effort to reach justice, or to give justice. All right, in its secular form. All right, but with regard to the nature of social legislation, I would like to zero in on the term measure, or the phrase measures legally justifiable, right? Because here, while social justice is defined as the humanization of laws, all right, and the equalization of social and economic sources by the state, all right, the question would remain: what would be the means through which the state humanizes the laws, through which the state equalizes the social and economic forces? All right. Here we can zero in on the phrase measures legally justifiable, because these are the means through which the state carries out the ideals of social justice. All right. And these measures, which are legally justifiable, all right, we will not discuss the extra constitutional, because that's outside the Constitution. And social legislation presupposes that it is there, it is enacted within the framework of a constitution, within the framework of a of the highest law of the land. And so here, when it comes to measures legally justifiable, we are alluding, or this definition is alluding to social legislation. All right. Social legislation, therefore, by nature, of course, they are laws, because they are passed by the state, they are enacted by the state, but their by nature, they are the means through which the state, right, humanizes the laws and equalizes the social and economic forces, right, in order to promote the welfare of the people and in order to approximate justice in its secular meaning, right? Here, government measures, right? Social legislation, okay, are government measures. And these government measures are geared towards promotion of social justice, geared towards the humanization of laws and equalization of the economic and social forces, etc., etc. All right. All right. Now we've come to the last part of our brief discussion on the introduction of social justice, and because there are varying inequalities, in society, because the inequalities in society present themselves in many forms, in many ways. All right, and so social legislation also takes several forms. All right, takes several kinds. Okay, and they may be categorized depending on the kinds of uh, of the social legislation, no? Depending on the problem addressed. All right, such that here we can say that there are inequalities with regard to representation, perhaps, or inequalities, social inequalities, depending on on being the marginalized group or the main group, for example, or the dominant group. All right, such that there are pieces of social legislation which can very well be categorized as marginalized and representation laws, for example. Uh, Siguro, one law that I can cite here would be the IPRA, the Indigenous Peoples' Rights Act, all right? Because considered as marginalized, indigenous peoples feel that they need the law. Of course, they really do need the law. They really do need a law that will entitle them, that will recognize, no? Because their argument is that they are already entitled to their ancestral domains by their continuous possession since time immemorial, like that, uh, and also some rights with regard to participation in the government, for example. All right, these laws of such nature may be categorized, may be considered as marginalized and representation laws. All right. There are also, of course, you know this. You are very familiar with this. When it comes to employment, right? The fact is that the employee is not equal to the employer, right? There is a gap between the employer and the employee, right? Because otherwise, had there been no gap, they would not be employer employee, but perhaps business partners, right? And sadly speaking, here the gap is more on economic because the employer has the capital, while the financial capital, but the worker, the employee, does not have the financial capital. No, just the industry, no, the his or her labor, okay, which he or she will sell to the employer. All right, and in that relationship, it's unequal, right? And in that unequal relationship, there may be some form of opportunity for abuse, perhaps, or there may be a uh, instances where the employees may be taken advantage. And so employment laws are placed in order for the employees to be given some form of protection, at least some form of protection from, let's say, excessive work hours, no, underpayment of wage, for example, all right, etc., etc. And so these laws, okay, may be considered as pieces of social legislation, employment laws. But with regard or in relation to employment laws, there are also uh, mga health and hazard protection laws. All right, where the undertaking or the business of the employer may expose the employees to some health hazards, to some accident hazards, and so in order to give protection to the employees, because it's the employees who are exposed to these hazards, while the employer is just there in the office with, and the reason why the employees are there exposed to the health hazard, to the accidental hazard, is that they have to work. They have to work for them to get to obtain money for living. All right, and so health and hazard protection laws are also put in place by Congress in order to protect these employees from such inequality, from such uh, hazard, no risk of health hazard and some accidental hazard. And lastly, perhaps we can say that there's also another group of social legislation where the general public, all right, are given the protection, okay, for uh, some events in their lives, some events which may cause instability, all right, with your employment, for example, instability with your capacity to earn, and therefore capacity to provide for your family, all right. uh, Unfortunately, not all people can, or not all Filipinos can survive, for example, a a completely loss of income for months. All right. There will be contingencies, all right, which may contribute to that. Right? If you're a billionaire, for example, if you're a trillionaire, for example, if ever you, for example, retire, or if ever you become permanently disabled, there's no problem there, or there's not much of a problem there when it comes to security of your future, because you're already a billionaire. Even though you are permanently disabled, for example, uh, you have the assets, you have the net worth that may carry you, right, or maybe enough or even more to carry you towards, let's say, until the end of your life. But that is not the case with most of the Filipino citizens. Most live day by day, week by week, month by month, such that if the earning capacity for even a day, a week, or a month will be hampered, will be discontinued, then there is a high possibility that this person will not survive, Worse, there's a high possibility as well that his or her family will not survive because they will not have the means to carry themselves through in the future, even when such contingencies happen. All right. So it's important, therefore, that a group of social legislation, okay, called social security laws, are also put in place in our legal framework to specifically provide security, all right, security to these Filipinos who, unlike the billionaires, unlike the millionaires and trillionaires, need, right, security in their lives for themselves and for their families. All right. And so, because of the time constraints in this course, because of the limited number of units, we will not be able to discuss everything. In fact, you have already discussed in your other subjects, siguro, employment laws and health hazard protection laws, right? Marginalized and representation laws, we may dispense with them, although perhaps in some subjects you will be able to discuss them. But here, this course, moving forward, we will focus on social security laws. So from module 7 to 10, we will discuss select social security laws in order for us to know the basics of these social security laws. Uh, our approach would be elementary, of course, the basics, the fundamentals of these social security laws. We will focus on the benefits, on the conditions of entitlement, and the criteria, the process with regard to these social security laws. All right. This ends our video lecture for module 5, and see you for module, I mean, sorry, this is not module 5, module 6. See you in module, in the next modules. Thank you.